Welcome, everyone, and thank you for joining us this afternoon. My name is Rachel Smythe, and I'm the Education Coordinator here at the Caregiver Resource Center, Orange County. The Caregiver Resource Center OC is a trusted partner for Orange County families who are coping with the physical, emotional, and financial responsibilities of caregiving. We're a not for profit agency, therefore, our services are free to family caregivers. By providing families and individuals with supportive services, Caregiver Resource Center OC stands apart as the only Orange County agency who focuses specifically on the needs of caregivers who are coping with a loved one's chronic illness. Services include family consultation, assessment, care planning, counseling, referrals for resources, psychoeducational seminars, respite planning, and community education. So, a lot going on. And we do also host a live stream the last Monday of each month. And you've joined us this afternoon for Ask an Elder Law Attorney, which is a live Q&A. We'll be taking audience questions, so please utilize the chat feature or comment section on whatever platform you're joining us from today, and we'll do our best to answer your questions. So go ahead and you can start now, get those questions going, and we'll do our best to answer as many as we can. And today I'm joined by Mr. Daniel York. And Daniel York is an elder law attorney in Fullerton, California. He's practiced law for more than 30 years and is a member of organizations that advocate for elders, including the National Academy of Elder Law Attorneys. Dan also chairs the North Orange County Senior Collaborative, which is a service group committed to identifying and addressing the unmet needs of seniors and their support systems in the North Orange County area. And thank you, Dan, so much for joining us today. I'd like to give you the chance to introduce yourself or share with the audience before we jump in. So I'm going to go ahead and I'll turn it over to you, Dan. And again, to the audience, as a reminder, please utilize the chat or comment features on whether you've joined us from YouTube or Facebook. Go ahead and start those questions coming, and I'll turn it over to Dan if you want to do an introduction for yourself.
Thank you, Rachel. I appreciate that. And I wanted to say first that it is an honor, a real honor to be invited by the Caregiver Resource Center and Rachel Smythe and the other good folks over there. By way of background, I should tell you that we are very blessed here in Orange County, California, to have many good organizations, of which I count the Caregiver Resource Center as a premier source of support for families. I bring also to the table, I think, a little perspective from having been the trustee and agent for healthcare and also for finances for a parent in a period of time that they were dealing with memory issues and a progressive illness. But I don't want to make it about me today. I want to make it about you. I wanted to just say that to say that I've kind of been on both sides of the table. And hopefully that will enrich our discussion today. I also want to make a quick reminder, because I know this is going out to a broad audience, that I'm licensed here in California. So I'm going to be speaking a lot about California programs. And if you are in another state, you would be well served to contact someone that's familiar with the rules in your state. I'm going to say this, I don't want to repeat it too often, but California's Medicaid program called Medi-Cal, which we'll probably touch on a lot today, has very unique rules, very unique to California. So don't assume that they apply in your state. I also wanted to say, as a general comment that you saw at the opening, your particular situation may be addressed in part through our discussion today, but chances are there's a lot more details that you might need to discuss with a professional. So keep that in mind, and you may want to contact an elder law attorney in your area.
Absolutely. Well, thank you so much, Dan. And it really is always a pleasure to have you on with us. We really appreciate your expertise. And I always tell Dan he breaks things down in a way that even I can understand. And so that's not easy to do. So we really appreciate Dan being here. So we could go ahead and we'll just start jumping into some questions. I can go ahead and, we already have some things coming in. So I'll go ahead and read that, Dan, and then give you that opportunity to answer. So we have a question that says, my mother created her legal docs in California, but then moved to an assisted living facility in Washington. Will her legal documents be valid in that state? And will her Alzheimer's diagnosis prevent her from making any changes?
Okay, so I'm going to hedge my answer a little bit on the first part. I see that legal documents were created in California and that the parent moved to the state of Washington. So the way this works in terms of documents, let's start with a trust. A trust is very oftentimes a centerpiece document that may control many of the assets, perhaps all of the assets. And typically, when a trust is created, there's a statement that says it was created under the laws of the state of fill in the blank, wherever that was. Um, Typically, also, the trust will be administered under the laws of that particular state. So it may be necessary to go to an attorney, perhaps the creating attorney, to answer some of your questions. Now, let me talk about the other state. That would be the state of Washington here. In many states, there is a reciprocity, a reciprocal arrangement, and in which the state, the new state, will recognize certain documents' validity. And you have to actually address that as to the particular documents. For example, in California, we we have a rule that states that if a power of attorney for finances was valid where and when it was executed, that it is good here in California. Okay. And the same holds true of the Advanced Healthcare Directive, which is our healthcare power of attorney document here in California. So if what was created, say, in Iowa was valid and good in Iowa and properly executed and completed there, then we will honor it. Let me go to this part B of the question as to the Alzheimer's diagnosis. And this is really an important point, and I really want everyone to pause and really listen to this. The diagnosis of any particular dementia, I know that's becoming a little dated, but any kind of neurodegenerative disease, such as a dementia, such as Alzheimer's, does not equal incapacity or inability or incompetence to sign new documents. Here in California, we have a very complicated functional test. And essentially, what it means when you break it all down is the question is, does this individual understand the consequences of what they're going to sign? Do they understand the things that they own? And do they understand the persons that will be benefited or affected by it? So those are all questions that typically we kind of begin to address in our early visits with a new client. It may sometimes be necessary to involve a doctor, but not necessarily. If I'm, for example, satisfied the person is giving appropriate answers, they have sufficient memory to know, even with a simplified explanation, what they're embarking on, then we'll be satisfied with that. There's a presumption, I should say, too, that here in California, anyone over the age of 18, no matter what their diagnosis is, are presumed to have the ability or the capacity to make these kinds of decisions unless there is sound proof to indicate otherwise. So there is a burden of proof by the person challenging it to show that they really didn't understand what they were doing. It can be kind of tricky, though. Sometimes midway through a disease or maybe in its latter stages, you may reach that threshold where they just do not understand the consequences of what they're embarking on.
And Dan, I'm also kind of monitoring some of the questions that might be coming in, and it looks like the same person says even if the person has two doctor's letters saying that she's not capable of handling her financial affairs. So in that case, if she does already have the two letters of incapacity or that she can't handle the financial affairs, will that aspect be honored in Washington?
depending on what what documents are involved and what they say about incapacity, that definitely can complicate things. And that actually raises another point that I think our audience may want to be aware of. I would suggest that if there are questions about capacity, that you may want to see an elder law attorney first. And they may, in fact, say, yes, it's time for letters of incapacity. Letters of incapacity become relevant when, for example, a trust has a definition or a power of attorney has a written definition that says, upon the finding of, say, two doctors, that's just an example, it's a common one. Saying that this person no longer has the ability to handle their own financial affairs. In fact, that may be a valid finding of incapacity. This is where it gets a little bit complicated in California because there is no single definition outside of the courtroom for when a finding of incapacity is effective. And very often, it really all depends on how the particular documents are written. Um, I do want to mention one quick thing. Um, you might find this unusual for me to say this, but in my practice and those of most of my colleagues, I think, most of the time, incapacity is not a question that really lands in the courts. Very oftentimes, it is interpreted according to whatever documents were put in place. So that's another good reason to consult with the attorney first so you kind of know where you stand.
Great. Thank you, Dan. It looks like there's another question that's come in, which says, what would be a reason siblings would keep other siblings from seeing their elderly parent when there has been no elder abuse in the past? There have been constant distractions keeping us away.
Well, I don't want to speculate.
Mhm.
But I would like to look at this from the point of view of the elder. And I'm an elder law attorney, and I just want to give our listeners and our viewers some perspective on this. Um, and I'm going to double back to the answer, okay? But it's very important to understand that as a family member ages, their abilities may somewhat diminish. Certainly, it's common to see memory kind of erode at times. But it's also important to realize that this person comes with certain um, presumed rights. And one of those things is the rights to see family members and to interact with friends and neighbors and do all those things that that person may still be capable of. So it's really very tempting as a person loses capacity or some capacity to kind of take over their lives. And that seems to be suggested here. Um, and I don't want this to sound accusatory, but one of the areas of elder financial abuse that we learn about from adult protective services is isolating people and keeping them away from their interactions with family and friends and others. So this can get into some fairly serious territory. I'm not making an accusation here. It sounds like maybe there were various excuses, and I don't know what those were, but it's really important to make sure that person's rights are honored and their dignity.
Thank you very much, Dan. Another question has come in, and again, everyone keep those questions coming. Let us know, and again, we'll try to get to as many as we can. But this question says, have $4,000 income and rent in a facility is over $6,000 now. Can you explain spousal impoverishment rule? Husband had dementia and our savings are diminishing quickly. May 86 years old and getting difficult to care for him myself.
Okay. Um, the spousal impoverishment rule is a Medi-Cal rule. And in most cases, it pertains to the most expensive level of care, which is a skilled nursing facility. However, not all facilities that provide care for seniors are skilled nursing facilities. A skilled nursing facility is sometimes called a nursing home or a convalescent center or a rehabilitation facility. And essentially, it provides the highest level of medical care outside of an acute care hospital, a medical center that we're all familiar with. Here in Fullerton, we have, for example, St. Jude Medical Center. But outside of that, it provides the highest level of care. Now I'm getting to the question. Um, I see that the caller is, or the participant is quoting some income figures and rent at the facility at being over $6,000. Well, I can tell if it is a California situation that the $6,000 is probably not in a skilled nursing facility because the average pay rate for a skilled nursing facility is over $11,500 here in California. So it probably has to do with what's called assisted living. Unfortunately, in most cases, Medi-Cal does not pay for assisted living. So this person would need to either be in a skilled nursing facility or if they could be at home with some assistance in a program called in-home support services. Now, let me talk about spousal impoverishment. The idea of spousal impoverishment is that if one spouse goes into a skilled nursing facility, you, the spouse, should not have to deplete all of your savings and everything you own just to pay that bill. And in fact, that's why Medi-Cal for long-term care was devised. One of the reasons. Spousal impoverishment rule was added later, and it essentially says that now currently in 2004, with some new rules in place, none of the assets of the stay-at-home spouse will be counted or required in order to pay that bill of the large bill of over $11,500 a month. Um, Also, the stay-at-home spouse is allowed to keep at least $3,854 per month as their monthly maintenance needs allowance. And that figure is arrived at once, and then typically Medi-Cal does not inquire into that again. So there are a number of protections under spousal impoverishment to protect the most expensive level of care. Sadly, as you can tell from my comment earlier, is that there's this big in between place between home care and uh, the skilled nursing facility, where the cost can be very high at $6,000. One thing I would suggest is that the caller our participant today, contact the Caregiver Resource Center. They have a lot of possible in between solutions that may involve, for example, taking advantage of respite care. Um, there may be an opportunity for in home support services, depending on what the income is. So I think the way you get down to solutions is you reach out to people that have answers, like the Caregiver Resource Center, and they can probably make other referrals. Another way to go, of course, is if you do need some help uh, in finding other resources, you could reach out to an elder law attorney.
Thank you. And then before we go on to this next question, I just wanted to see if you could share anything about your experience or any more about, because typically in a situation like this, although it is a very complicated and long process, if you could share anything about, and I'm sure you know what I'm going to say, the assisted living waiver, if you have
Yes,
any advice or any input or your experience with that.
sure. So I've been practicing over 36 years, and about half of that time has been in the area of elder law. So I have Among other things, I track very closely what's going on in Medi-Cal benefit programs, and I try as much as possible to stay in touch with organizations that, uh, really keep everyone up to date, the attorneys up to date on the rules and what's going on. So the assisted living waiver program regularly gets questions. So let me kind of break it down. First of all, and not to depress anyone here, but in all the time that I've been in practice, I've had exactly one client that qualified for the assisted living waiver program. Now, there may be others that later on qualified for it, but it's marked by long waiting lists to begin with. A few other comments about it. It has improved over time. It started out as a fairly limited pilot program, and now it's expanded to many more counties, and Orange County now is one of those counties. However, there are a limited number of spaces that are open, and what I'm hearing typically currently is that it can take anywhere from 1 to 3 years to get to the top of the list. A few other comments. Um, the idea of the assisted living waiver program is this: the person that needs that care would otherwise have to go into a skilled nursing facility, and they would prefer to be in a more home-like atmosphere. So they would prefer, if given the choice, to be in something that looks more like an apartment or a shared living situation and receive Medi-Cal benefits. The limitations on it are a little severe. First of all, there's a financial limitation. You cannot be accepted currently into the program unless you have no share of cost. And that means that your income, if you're an individual, does not exceed $1,732 with a few credits and offsets here and there. And if you are a married couple, let's say both of you are on Medi-Cal, that your joint income does not exceed $2,352 for a married couple. And by the way, those numbers are updated as of April 1 of this year. Okay. So there are many people whose income exceeds that. There are ways to offset the share of cost situation, for example, by buying supplemental medical insurance, which then gets subtracted from your income. So that is possible. The second thing to bear in mind is that you still must meet what's called the medically needy standard. That means if you were not in the assisted living program in that level of care, that you would otherwise qualify for a skilled nursing facility with the medical level of needs that most of us are familiar with at that level. So again, not to discourage people, but I do want people to understand that it is still difficult to get into, and in most cases, there are waiting lists. I didn't even go into some of the other details. For example, to qualify, you have to register with a care coordination agency, a CCA. And by the way, this information is available on the Department of Healthcare Services website. They actually have a list of the different care coordination agencies, and you have to actually be referred into and approved by the CCA in order to qualify for a space in an assisted living bed. So there are a few hurdles.
Yes, it can definitely be a challenge, and anyone who is in that situation and looking for support or looking for guidance, again, just like Dan mentioned earlier, call us at the Caregiver Resource Center. These are areas that we deal with pretty regularly when it comes to the waiver programs and Medi-Cal. So we work with a lot of different entities. So if you have questions beyond what we can cover today, please do contact us as well, and we can try to support and guide to our best ability. Okay, so we have another question here, and it is: when is a good time to help a loved one complete legal documents such as a living will, living trust, or advance health directive Do we need to see a lawyer to do this?
When you're dealing with someone who has a progressive condition, may have a new diagnosis, and there may be some uncertainty about how quickly their condition will change. I would say to answer that, I'm going to try and answer this question as directly as I can. Um, I recently read that 1 out of every 3 persons in the United States over the age of 80 have been diagnosed with some level of dementia, what is called dementia, or memory loss. It may be more severe in some than in others. So, with that in mind, we have to go back to our old friend incapacity, okay? And you have to understand that when you present in a lawyer's office and the attorney is getting to know the senior or the elder for the first time, they're watching, a good attorney will watch for cues that this person is understanding the process in front of them. And sometimes updating or even establishing for the first time these documents that appear here on our question can take time. Um, Frankly, there are a lot of questions. For example, um, if you lost the ability to manage all of your financial affairs, your credit cards, your bank accounts, determine what needs to be fixed or what bank you're going to bank with, et cetera, who would you trust to do that? Well, that's a big question. Among other things, you may want to talk about it with the person you choose. They may or may not have the time and feel that they can devote themselves to that task. Another question, for example, is who would be their alternate if they can't do it suddenly because of health reasons, or they move away, or they get too consumed with other matters of life. So everything that has been listed by the caller is a planning document requiring looking into the future as far as you can and figuring out what you want to happen both during the latter part of one's life, maybe when you're not well or you don't feel up to managing the finances, and thereafter. That is, what becomes of everything is left afterwards. Um, Sometimes the decisions just require a little bit of time to absorb. I mean, all of us, I think, take those kinds of blocks of time when we're making a decision like what kind of car to buy or where you want to live, and do you want to rent, do you want to buy, et cetera, et cetera. So think of planning as at that level of complexity. So the answer to the question is as soon as possible. Okay. Um, we encounter a lot of folks through no fault of their own that come to us because their relative, their loved one, has simply not gotten the planning done or has not updated it in many, many years. So I would say that if you see that situation, start now because you're going to be surprised at how long it can take. Do you need to see a lawyer to do this? There's only one document on the list, the Advanced Healthcare Directive, that I can say with some confidence that you could complete by reading the directions and thinking about your answers and discussing them, that I would feel confident that you could handle it. Okay. The other documents like the living trust or the advance or the power of attorney for finances can be complicated by your particular needs. And for example, we haven't even touched on Medi-Cal, the way the Medi-Cal rules will interact with your particular finances. So I do not recommend that you try and do that on your own. The other thing to remember is if one owns real estate, for an example, or you're going to put certain assets in the name of the trust, you really need good advice on how to make sure that the titling on a deed is done correctly and that the particular asset really does belong in the name of the trust. Not all assets belong in the title of a trust.
Thank you, Dan. And okay, another question here. Is there a standard form in California that doctors sign for incapacitation? It's a long word.
Yes. Uh, the the short answer is no. I'm probably going to over-explain, so just signal me if I'm going off here a little bit. In California, there is a proceeding in court called conservatorship. In some states, it's known as guardianship. And in that limited setting, the courts do require that the doctor who gives an opinion about incapacity, that is, the inability of one to manage one's finances and provide for their housing, food and shelter and so forth, and who are unable to resist fraud or undue influence. There is a particular form that the doctor giving the opinion to the court will have to complete, sign, and deliver to the court. But it is not suitable for all findings of incapacity. I want to drive this home. Very often, the documents that we talked about earlier, the power of attorney for finances or the trust, will have their own built-in standards for determining incapacity for that particular document. So the answer is there is no one standard form that fits all situations.
Thank you. That's helpful. And then let's see here. Another question is, what should I look for when I'm buying long-term care insurance, and how helpful is it?
Okay, so what we found over the years is that long-term care insurance was fairly popular in the 1980s and even in the early part of the 1990s. But somewhere near the end of the 1990s, uh, and I'm getting to your answer, but somewhere along in that time period, a lot of insurance companies started not selling it as much as they used to. And a lot of those companies have actually withdrawn from California. Um, if you can purchase long term care insurance, I have a few tips in what to look for. If you are a city, county, state, or federal employee, and if your employer has an opportunity for you to purchase long term care insurance, that can actually be a pretty good deal. Among other things, these companies tend to want to keep the employer happy, so they are not just selling to one isolated individual. And those policies can actually be pretty beneficial to the purchaser. Among the many things that you need to look at when you look at long-term care insurance, and we can't cover them all, but you need to be sure that your particular um, area of concern, whether it's Alzheimer's, other dementias, look in the definition section, ask the agent whether these are covered. So that's one thing to look for. Another thing to look for is what's called the elimination period. The elimination period can mean that if you are diagnosed with one of these illnesses, that you may have to pay your own care bills for a specified period of time. It could be 60 days, 90 days, whatever. So build that into your budgeting and into your planning and to comparison. The other thing to remember is that many of these policies do not provide, with some exception, do not provide lifetime coverage. So they may be limited to 3 years of paying for a certain level of care or 5 years, etc. There are many other things to consider. What level of care will they pay for? Is it only skilled nursing care? Is it care at home? Is it assisted living, which we mentioned earlier is not very well covered by the Medi-Cal program? So if that's something of interest to you, that's something to cover with the agent. The other thing to consider is the cost of the programs. Now, you said, what should I look for when I'm buying long-term care insurance? Many long-term care insurance companies, of course, most of them are looking at this as a business decision on whether to offer you a policy. So typically, if you are approaching 60, and if you're over 60, you're much less attractive as a potential customer because there's a period you're not going to be paying in premiums for as long a period as somebody who starts earlier. Um, so that's something to think about. Um, Also, if they do a health questionnaire, as they probably undoubtedly will, or even an examination, you may not qualify. So this is just a real light overview of some of the things to think about.
Thank you. And then I am trying to get conservatorship of my mom, but do not have a power of attorney. What chances do I have to get a conservatorship? I am the eldest daughter, and my niece obtained the power of attorney without notifying us.
Okay. So a conservatorship, as I said earlier, is a court proceeding in which the court makes certain findings um, in the beginning, principally about whether the person in question actually needs a conservatorship. And one of the things that the court would consider is whether a power of attorney or a trust will otherwise meet the needs of that person. And, you know, in families, there are very often differences of opinion about how the care should be provided. But when you go into conservatorship court, the judge's decision on these matters is normally at that person's discretion, at the judge's discretion, after having done a very thorough background check. One thing I should tell you about conservatorship is that it is very detailed and it is somewhat intrusive. It involves the opinion of a doctor or doctors, maybe more than one. There is a court investigator that interviews the affected people and those that are familiar with the person who may be conserved. The proposed conservatee is what we call it, and that person may make recommendations about whether this person's needs are being properly met or not, and that will of course affect the judge's view on things. But there is an open hearing, and it is typically family members are notified and can show up in court and can give their opinion about things. So when you speak about conservatorship, that is a very detailed court controlled situation. A POA does not require a court's approval. So if the POA was properly executed and if the person knew what they were doing, they don't necessarily have to notify other family members, because if it was done with knowledge and capacity by say a senior person, that is their right to choose who they chose. That is not an unlimited rule, of course. If they were coerced or pressured or suffered under some undue influence, then that may be something that basically breaks the POA, for lack of a better term.
That's helpful. Thank you. Okay, another question. My husband and I live with and take care of his 96-year-old grandmother. I've cut back my work hours to be home for her safety. Her home is in her name in a reverse mortgage. Can we get financial help?
Yeah, the first thing that comes to mind here, um, since you have made this commitment to care for your grandmother, is that depending on her income, uh, and I said only income, not her assets, that she may qualify for the in-home support services programs, IHSS. You can learn more about the program through the Department of Social Services here in Orange County, for example. or you can go to the California Department of Healthcare Services and type into the search box IHSS. The IHSS program will pay relatives and those providing care on an hourly basis. The hours are not unlimited, they have to reflect the particular assessed needs of the person. So there's typically going to be an in home assessment to determine what that will be. Uh, the pay is not very high. Typically, that would be minimum wage level, and of course, taxes would have to come out. All the things that are normally associated with an hourly pay, um, but but you could, in that situation, receive some assistance through IHSS.
Yes, and I would encourage you to give us a call here at Caregiver Resource Center, and we can help guide you through the process and talk more about what might be available for you. And we do have social workers mornings, afternoons, ready to answer the phone and answer questions that you might have. Okay, next question here is, please speak about the 250% Working Disabled program.
Okay. So the 250% Working Disabled program is a Medi-Cal program. And whenever I mention Medi-Cal, it's best to think of Medi-Cal as an umbrella of many different programs, of which this is one. Um, this is going to be a fairly short answer, but I will tell you that, first of all, the person qualifying for that program must be qualified as disabled within the definition of the SSI program, the Social Security rules. That means they must have income from the job. It has to be income above a certain level. Um, the income has to be under 250% of the federal poverty level. And I don't have that number at hand right off, but I can tell you that the 130% level is $1,732 as of April 1 of this year. So, I'm eyeballing this here a little bit. It's probably somewhere around $2,000. Um, the Working Disabled program uh, enables you to take advantage of Medi-Cal as medical coverage for doctor visits, for hospitalization. It's actually Medi-Cal is actually a very comprehensive program covering medications. It is a great safety net program, particularly if you do not yet qualify for Medicare because you're still working. And so, what I would do if I were you, if you want additional information, you might want to write down the following website. And I think Rachel is very familiar with California Advocates for Nursing Home Reform. So, their acronym is their website. It's CANHR, that stands for California Advocates for Nursing Home Reform .org, and you can look up Medi-Cal programs, and you can type in 250% Working Disabled program, and they can give you more information on that and any number of other Medi-Cal programs.
Yeah, that's a great resource. We utilize them all the time, and they've definitely been a huge help for a lot of individuals. Okay, another question here is, all income and savings are in a trust. Banks refuse to recognize section in trust that trustee can assign someone to handle finances for him. Daughter has power of attorney for husband, and I have turned things over to her because I have been getting confused lately too. But they will not accept that, and she is just handling it without anyone aware of it. What good is a trust if one has to go to an attorney to change things when one needs it?
Okay. Well, that last question is a great question, but I guess you could say that's one of the limitations of a trust. Um, the important thing here, I want to go back a couple of places here and make sure that everybody understands the advantages and also the limitations of a trust. So the advantage of a trust is that you can privately decide how you want money spent before you become incapacitated or before you need help, and what becomes of what you own after you pass away. But, we're all human beings, we're not pieces of paper. And we don't just freeze in place, we actually change. Our lives change. We may need some additional help, as the questioner mentioned. And so, what happens is this: when you put your account into the name of the trust, most banks are looking only for one type of decision maker, and that's the trustee. So I don't want this to get overcomplicated, but I want to make this really clear. When you set up a trust, you are the trust maker. And in most cases, if it's in a time of your life that you're young enough and healthy enough and want to manage things, typically you will manage your own accounts. But later on, when you don't feel up to it, or maybe you're not well enough to take care of those things, then it may be time to change the trustee. It may be time for you to use the mechanism in the trust to resign and designate someone else to be the trustee, even if you don't change the other provisions of the trust. So, to the questioner, it might be that time. It might be that time. It's also important to understand that the power of attorney and the trust are separate documents. And if an account is held in the name of the trust, then the bank or other financial institution wants to only talk to the trustee. Yes, I'm familiar with trusts that say that the person can sign a power of attorney, but in my experience, banks are fairly rigid about this, and they disfavor overriding the trustee powers with a simple power of attorney. Um, a power of attorney can be very easily changed, and many banks find them not reliable. They're very often challenged and questioned. So the bottom line is that I think you need to find out why they're not honoring the POA, and if it's because they want to only deal with the trustee, it may be time to change the trustee.
Thank you, Dan. And how can an attorney prove if an elder is coerced or intimidated into signing documents? So, I guess what safeguards are in place to ensure that someone is able to sign and that it's done appropriately and in the correct manner?
Yeah. Well, there's a couple of things here to think about. One of them is whether you, as the concerned person, have access to the elder and have some indication that these are not their wishes. So, for example, let's talk about the idea of undue influence for just a second. In the law, we say that undue influence can be indicated by a number of things. One is whether there is a sudden change in the way that money is managed and spent, and whether the person who seems to be benefiting is the one that has the most control over that person's life. Now, this is not this is not a slam dunk finding, and it's not an accusation that that person is intimidating or coercing or exerting undue influence. But our laws say that these are things that we look at when we're talking about the idea of undue influence. So those are some things to consider. Um, this area of elder financial abuse is a very difficult area to operate in. Uh, Not every elder law attorney actually takes cases like this. because they depend a lot on proof that's difficult to get. And very often within families, the elder is kind of caught in between, and they don't want to report someone that may have done something incorrect. We're all very protective of our family members very oftentimes. So proof can be a very difficult thing. Um, I would tell you this, and I know that I'm probably going to get some comments on this, but Adult Protective Services is a county office who is charged and authorized to follow up with complaints about elder abuse, elder isolation, coercion, intimidation. And while they depend on enforcement authorities like the DA's office and law enforcement, very often they can be the first eyes from the outside on what's really going on. They can interview people, they can kind of size things up, and they can at least open a file to track things, even though a lot of people get a little impatient because they think they're going to come in with the red lights and the sirens and everything is going to be made right now. I would say that elder financial abuse is, you can probably tell by reading the papers, is a real plague. It's a real difficult problem. And I would say that it's very important if you care about someone to stay in touch with them, stay connected with them, and stay ready and willing to help as you can. Um, that's probably not going to be a real satisfactory answer, but those are a few things that come to mind.
Sure. Thank you, Dan. And depending on what's going on with the situation, Adult Protective Services can be a really good resource as well, even just to ask questions, get information. We always encourage people to reach out to them and ask questions, consult, talk about what's going on, and see if there's any other supports or resources to help. So that's a great thing that you brought that up, Dan. Another question here: is a memory care facility considered a skilled nursing facility?
So, the term memory care facility, we see this a lot. Um, More often than not, I see memory care facility associated with assisted living, or what are oftentimes called board and care facilities, and not as often associated with skilled nursing. So let me explain that a little bit. They can be, by the way, associated with skilled nursing. Um, Memory care typically has to do with the training and the familiarity of that facility with the special needs of people that are beginning to lose memory and they're beginning to lose their ability to retain information and function. So they very often bring a lot of skills and special programs and socialization opportunities, um, coupled with um, just very mindful monitoring of that person and where they are and making sure that they don't wander away from their living facility. So it has to do with sort of a bundle of those kinds of services. Um, the assisted living facilities are regulated by an agency of the state government that is completely different from that which regulates a skilled nursing facility. At the highest level, that is a skilled nursing facility that um, also has a special unit for those with severe memory problems, they may be allowed, for example, to have passcodes on doors so that their residents do not wander away. But that has to be specially regulated, and they have to be approved for providing that level of care. Yeah, memory care very often is I guess what you would say, a fairly loosely used term, and it is not always carefully regulated. I think a lot of times it's just a matter of whether that facility is oriented towards that kind of patient. The other thing to be aware of is that some folks with memory care issues can also have severe behavioral issues. And sometimes that's a kind of a code for saying we are willing to evaluate and consider taking in this person, even though they may have had some severe behaviors.
Sure. And then we'll go ahead. This will be our last question. And then I just have a question for you, Dan, before we close out after
Sure.
this. But so our last question here is, I have a durable power of attorney, an advanced healthcare directive decision maker for my life partner, unmarried nor registered domestic partners. Close family friend strongly urges conservatorship. Do I need it? I don't want to if I don't have to.
Right. I would say, to get a definitive answer on that, um, you really ought to see a professional. You should see an elder law attorney. And here's one of the reasons it springs right to mind. Uh, we've counseled people in partnerships that are not married and they are not registered domestic partners. And one of the issues that can come up is this question of ownership. And when you're in either a marital relationship or registered domestic partnership, you have the benefit of owning community property that is the property of both. So that even if you don't change titling or you don't do something special with respect to a trust, that ownership is sort of automatically handled. But that's not true when you're not married and you're not in a registered domestic partnership. So that can become a real issue. I would tell you this: the Advanced Care Directive, as we probably all know here, I hope, only deals with medical decision making, no financial decision making at all. It's a good thing to have, very important thing to have. The power of attorney, the DPOA for finances, can be useful. And I want to repeat something I said earlier. They are very often challenged by banks and other financial institutions. So if that bank and financial institution has not already sort of cleared your involvement as the agent, they're not familiar with you, maybe they've not seen the power of attorney until some crisis, they may be apprehensive and they may not accept its authority. Um, Financial institutions do a lot of things internally and make their own rules that are not written in the law anywhere. And so they can refuse to honor the POA if they have reasonable doubts, is the term. It's one of the reasons that I mentioned a moment ago about maybe even looking into a trust, which is a far more powerful and effective way of gaining control in these situations. Um, Conservatorship is getting more and more difficult. There are new laws that have been recently passed called supported decision making, and I don't want to use up all of our time, but I do want to tell you that these laws were passed in the wake of the scandal involving the Britney Spears conservatorship. And so the protections for the proposed conservatee have been increased, but the acceptance of the conservatorship have been made more difficult. I would not rely on that as my solution if you can manage to do something earlier.
Thank you, Dan. And then the last question I was just wondering is, what is one thing that you wish those who are listening today or who will watch this later on, what is one thing that you wish that the audience would know about long-term care planning, whether it be financial, legal? What's one kind of big piece of advice that you wish people were aware of?
I'll give you two for the price of one, Rachel.
Perfect.
One is start early. Never think that you've started too early. And by early, I mean if you're going to begin to work with someone, allow at least 3 to 4 months to get the project done. Okay, that's number one. Number two, is if you trust someone to name them as trustee, medical agent, or POA agent, then if you are of an advanced age or you have a progressive illness, begin to involve them in the details of your finances and your wishes. Do not wait until a crisis. They need to feel comfortable that they know what to do and what your wishes are and how all the pieces fit together. So, those are my two best pieces of advice, I hope.
Great. Thank you so much, Dan. That's very helpful. And I just want to say thank you to everyone who joined us this afternoon. And of course, another special thank you to you, Dan. And we hope this information has been helpful to you all as you navigate the very complicated and complex area of elder law, long-term care planning, and caregiving. And I would also like to share that next month on Wednesday, May 22nd, our agency will be hosting a workshop called Virtual Legal and Financial Planning, and that's in collaboration with the Alzheimer's Association's Orange County chapter, as well as Daniel York, who will be our guest speaker. That workshop will be from 10 a.m. to 1 p.m., so it's quite a bit longer, and we will have a short break during that time, but that will go a lot further into depth on important legal and financial issues. Dan will then join us again after that, 1 week after, for a follow-up on any questions that come up during the legal workshop that we just don't get to. We've set him up for another meeting with us for kind of a similar to this situation, a Q&A. And then if you'd like more information on these classes or any other educational programs that we offer here, please go ahead and check out our website. It's on the screen there, which is caregiveroc.org, or you can always call our offices at 714-446-5030 for more information. And thank you again, Dan, and thank you everyone who joined us this afternoon, and everyone take good care. Thanks for being here. Thank you, Dan.
Thank you.